Hey, everybody, this is Tim Blanchett with divorce661.com. And this is the first episode, our first live broadcast where we're offering free help. We might go for 30 minutes, 45 minutes. We'll just see how many people come online and ask questions. We also had several people ask some questions during the week that we have prepared to answer, and hopefully they'll be joining us to hear the answers to their questions. And what we're doing is we're talking about issues with your paperwork, problems you're having with getting through the divorce process. Maybe you have a couple issues with the judgment and you need a little quick fix or a little advice on how to correct that form. So we'll be going over all of that. If you have your question, please put it in the comment or chat section. It's going to be a little bit different depending on what platform you're on, whether it's YouTube or LinkedIn or where else do we have this streaming? Facebook. So you go ahead and chat your question and we will get to it when we can. In the meantime, till that happens, I'll be going over the questions that were submitted to us by email, and we can do that. The first thing I want to talk about is the Court Self-Help Center for Los Angeles County. They've come quite a long way in helping folks get through the divorce process, but it's just still, how do I say this, a government agency, and they can only do so good. What I mean by that is I was just looking at their self-help online guides, and I have to say they make it more complicated than it needs to be as far as helping you get through the divorce process. So if you want the court's self-help to use the court, this is what page 1 of a 30-page packet that they are saying is the worksheet for workshop 1 of 3. So their process is, and I was going through it earlier just to see what you're up against if you're trying to do your own divorce, is step 1 is to watch about 20 videos, and they're good videos about the divorce process and how it works and the definitions and so forth. But then your next step is to do this first set of this big packet. And it's literally 30 pages. And it's everything that you would need for your divorce, as far as listing your assets and debts and expenses and all this. But this is complete overkill if you're going through an amicable divorce. It goes into extreme detail, essentially preparing you ultimately for what would be a trial with the amount of information that they have you complete here. And to keep in mind, once you get through this 30-page packet that you would do on your own, then and only then can you call the Self-Help Center here to schedule an appointment to talk to the Self-Help Center and maybe sit down with someone. I think they're even doing these by Zoom, but they will go over this with you. And from what people are reporting is it's about a 2-month wait just to get into the court. So if you're just joining us, we're talking about how the Self-Help Center have come a long way, and this is specifically LA County, but they're still making it a very difficult problem as far as the amount of paperwork that you have to get through. And I was sharing this 30-page document that the court has you fill out simply before you can ask them and make an appointment for help for your paperwork. So I know what you're having trouble getting a hold of people, you're having trouble getting help. And that's why we're doing these free Friday advice sessions here. We're trying to do this every Friday and answer your questions. So anyways, I get it. It's trouble. It's problematic getting help from the court, and that's why we're here. Okay, so let's get to some of the questions that we had come up over the week, and we've already have them plugged in here. And again, submit your question through the comments. I'll be happy to answer your questions regarding your paperwork and the divorce process and so forth. Or you can email us later in the week, and we can answer them in the following video we'll do. Again, we're going to try and do this every Friday. So here was the first question that we have for the day. How do I complete the FL 343 in a default case when there are no issues of spousal or child support? Do I terminate jurisdiction for both parties? So the 343 is, and I have the form here. The 343 is basically the spousal support order attachment that you will attach to your judgment, which is the FL 180. And you'll do this in all cases, even if there is not going to be any support. But the question that's interesting here is, and I'll be talking about this at the end, the default with agreement versus default without an agreement. This question leads me to believe that when she says a default case, that there is no agreement. And if you watch my videos, I say the default cases are the most difficult cases to get through. We're talking default means no agreement, no participation from the other party. And what makes that even more difficult is this person's asking about support in both spousal and child support. So these default cases with no agreement are difficult enough to get through, even if there's no assets, debts, or children or alimony. But when there are children involved, these true defaults are going to be extremely difficult to get through the process. So that would be my first warning. Because the court's going to bring you into court. There will be a hearing when there's children involved and there's a default and the party's not participating. The court's going to want to know, why is this other party not participating when there's kids involved? Why are they not wanting custody or being involved in the children's lives? So you definitely are going to go to court for multiple reasons. But to answer the question, the specific question, as far as if there are no issues of spouse support, or child support, do I terminate jurisdiction for both parties? The answer is, it depends on what you put on your petition. So let me show you the petition, and this is why the default cases are so tricky. On the petition, when you are completing your divorce paperwork, when you're doing your initial summons and petition, here in the spouse support section, number 8, this is where you need to look. Did you mark terminate the court's ability to order spouse support to petitioner and respondent? If you did, then you can mark that on your judgment, on the 343 spousal support order attachment. When you have a true default and no participation in the divorce from the respondent, the judgment needs to mirror exactly what you put in the petition. So to answer your question here, if you marked terminate the court's ability to both parties on here, then yes, on the 343, you will mark the same thing. Now, if you marked reserve jurisdiction to both, that's what you need to mark. You cannot change anything on a default judgment with no agreement. True default judgment, what that's characterized as. You can't make any changes because the theory is that the party didn't respond because they are in agreement to what you requested in your petition. So you can make no changes. Now, one of the issues that'll come up is we have parties married longer than 10 years, and on the petition, they will ask to terminate spousal support. And then it'll be a true default, and the other party won't be participating, and they'll try and submit their judgment as a true default, terminating spousal support on a long-term marriage, and their judgment will get rejected because you cannot terminate spousal support on a long-term marriage without an agreement to that effect. So what ends up happening is, if it is a true default and you submit a judgment for terminating spousal on a long-term marriage, even if you marked on the petition, the court's going to reject it, saying you can't mark terminate without a mutual agreement. So if you then go to change your judgment, this would be your thought process. Well, I'll mark reserve because that's what they'll tell you to do. And then you resubmit your judgment. The judgment will get rejected again because you didn't mark reserved on your petition. You marked terminate. So what does that mean? If you want to get your judgment through, you have to amend your petition to reserved. If in this particular case, refile it, reserve it, wait 30 days, and then you can submit your default judgment, terminate support. So it's a very tricky, and this is the case with everything in regards to defaults, how difficult and tricky they are to get through. I always tell folks, use this as a last resort. Default should not be something you do just because you don't want to bother the other party, or because it's going to be too difficult to get their cooperation, or they don't want to sign. We hear this a lot. He doesn't, the respondent doesn't want to file a response and pay the court fee, so we're just going to do a default, but we're in agreement. It doesn't work that way. You can do a default with a written agreement. Again, we'll be talking about the differences at the end of this show, but default, true default, no agreement, very tricky to get through. Treat it as a last resort. So I think we answered everything on this particular question. Regarding the child support, you can't terminate jurisdiction for child support. So let's touch on that. Spouse support, yes, in some cases you can by agreement. You always can. When it comes to child support, you cannot terminate the court's jurisdiction. You can't even ask for zero or ask for it to be waived. So what this person is going to have to do, and like I said, on true default cases, there's always going to be a hearing. The child support is going to have to be a factor. It's going to have to be determined. and you're going to have to go into child support services at the court the family court and have them run a calculation based on incomes to determine if there needs to be child support. Now, if you don't know the income of the party, that's a different story, but the judge is going to have to order child support, because the ruling with the judges, they've said this at a high level, that every case shall have child support. So if you're going through a default hearing, no agreement, there's going to be child support unless there's no income from either party. And the numbers, when you do the math, works out that there's zero child support. Now, that's on the default side of things. When you go through an amicable divorce, a default with written agreement, like with our clients, that's all we focus on. They have the ability to make any decisions they want. They can have no child support. They can, again, they're not waiving it. They're just saying, yeah, child support was calculated at X, but we agree that child support will be zero. And we have some language we put in there to make that happen. So if you're going through an amicable divorce, there's a way of having that happen. You can terminate spousal and long-term marriage through a waiver you would sign. And we have special language to have child support set at zero. And we get a lot of flack from this because people say, hey, how are you getting zero support orders through the court? It's called a non-guideline order. There's actually a form for it. And you basically say, here's the spousal support calculation. Let's say it was $1,000, but the parties agree and not under duress that it's in the best interest of the minor children that spouse or the child support be set at zero. So we do that all day long. Lots of our clients, even though there would be child support built in, they just don't want an official court order for whatever reason. They're handling their kids financially outside of court, and that's totally fine. Otherwise, the courts would not allow that. Okay, let's go on to the next question here. So the next question that was submitted was need help. And I've paraphrased these. We got these in email form, and I've kind of paraphrased and tried to keep how the email was written to us so that person that may be watching knows I'm answering their question. But need help. My husband will not meet up with me or tell me what city he is staying in. I have filed the papers already. What do I do? Okay, so this is going to go to the need for service. And we get this question a lot in different ways. The simple answer is your spouse needs to be served one way or another. And I think in the last week's episode, we talked about this. So you can go back to that and watch that, because we covered all the different ways that you can serve your spouse. Look for the video. I just remembered. It was called 6 Ways to Serve Your Spouse. And I talk about the different ways you can do that. But you need to locate your spouse. What we talked about in that other video was after you filed and you need to serve your spouse, if you don't know where they are, what most people ask me is, hey, Tim, can I do a service by publication? And while the answer is kind of yes, the true answer is really no, because the court has to approve these service by publications. And I'll bring up the form. Again, I don't want to go over it too much because we talked about it last week, but before you can serve your spouse by publication and you don't know where they are, you have to jump through all of these hoops as far as what you have to prove to the court you've done in trying to search for your spouse. So they're up into including hiring a private investigator to locate them. You need to check with family. You need to check the phone book. You need to do a Google search. You need to check social media. You need to contact past family members, go to past houses. You have to do a lot of legwork. They make it so difficult to get approved for a publication, service by publication, that if you follow all of the rules before they allow it, you're going to actually find your spouse. So just take the effort to find them, do the research. It's going to be easier to do it by regular, personal service or whatever other method other than publication. So take the time to try and locate your spouse. You're going to have to do that. And the other thing with this question, they said they had already filed, which is interesting because when you file for divorce, you need to indicate the address of both parties. So I'd be curious as to what address was used at the time of filing. But yeah, locate your spouse. You're going to need to do that. They're going to need to be served. Let me just add one thing to the publication. That is, again, a last resort, and it's going to add a bunch of time to the process, because first you have to file a motion to request publication. First, you have to do all the legwork. So that's going to take you a couple of weeks. Then you have to do the publication request to the court, file the motion. They're going to review it. That's probably going to take a couple of weeks, a month for them to approve that. Then let's say you do get the approval of the publication. Then you have to publish in the newspaper for 30 days. Then 30 days after that, that's when they are considered served. So you're adding, call it 4 months before they're even considered served. And that's when you start the clock on the 6-month process. So it significantly delays the process. All right, let's see what our next question was here. My daughter is turning 18 and I need to file an amended income withholding order. Do you provide this service and how much does it cost? So the income withholding orders, if you don't know what this is if you have a child support order, it could also be a spousal support order, but generally it's a child support order. And then an additional income withholding order was filed. So let's say child support was ordered at $500 and they do an income withholding order. Just means they're withholding the income from your payroll. It gets served on your employer and the money is going directly to California State Disbursement Unit for child support collection directly from your employer. So yes, we do handle these. We handle them a lot. Generally, we're handling them around the time that the kids are graduating high school, because keep in mind to terminate child support, you have to meet two criteria. They have to turn 18 and they have to graduate from high school. So until that happens, you can't file the order. You can't even file them. We've tried to submit these early because what will happen is they can take a long time to get filed, sometimes 30, 45 days. We submit them to court, and that's going to always cause some type of overpayment, at least for a month, but usually two. And that was back maybe a year ago, 6 months ago, when everything had to be filed by mail or just drop off to the court. But now with the electronic filings, we're seeing that filing timeline significantly drop to about 2 weeks. So that's nice. Everything with electronic filing has been a godsend as far as what we do and getting divorce cases through the court quicker and getting things filed faster. So again, 18 and graduate from high school. I did speak with this person as well, and they turned 18 before they graduate. So we still have to wait a few months. And again, around June, July, and when the kids start graduating from school, we get an influx of people requesting to have these completed and filed. So if that is you, we can do that. I just need a couple days to get that prepped, get signatures, and get that submitted to court so we can get that turned around quickly and then out to your employer to stop the support. Okay, next question that came in. Okay, this is a good one because we get this like 3 times a day. My wife and I got married in India. And keep in mind, the question can be in any country or any other state. They'll say, hey, we were married here or there, anywhere other than California. We both live in Los Angeles County. We were married in Orange County. Where do we file for divorce? So the simple answer is you file for divorce where you live. Makes no difference where you were married. If you had some destination wedding or were married in another state, you're still going to get divorced where you live. So it's not going to, in this case, they were married in Orange County. They're not going to go get divorced in Orange County. Imagine if you live in another state and you were married in Orange County or any other county in California, but then you had to go file for divorce in that county. That wouldn't make sense. So you file in the jurisdiction you currently live, regardless of where you were married and regardless of where you are from. So that's going to be the case all the time. And again, we get that question a ton. So wherever you live, that's where you file. Now, this is where I was hinting upon earlier, the default with agreement versus default without an agreement. We treat default without agreement as a last resort. They are very difficult to get through the courts. Everything becomes a matter of law. You get to make no decisions. For instance, if you and your spouse agree verbally that, hey, you can keep this and that asset and debt, and you want to divide things different than equally, you can't do that on a true default. You have to divide everything equally, even if it's not fair. And I can give you some, I guess there could be a horror story in a sense. This was several years ago. We had clients where this was the case. Husband said to wife, you can keep all of your 401ks and pensions. I don't want any of it. And, I don't want you can have the house. I don't want anything, but he refused to participate for some reason. What that made happen, even though they had a verbal agreement that he didn't want, we're talking, several $100,000 that he was waiving verbally, but he wouldn't participate at all, even as a default with written agreement. Forget about having him respond. So what that forced us to do is you have to refile it as knowing it's going to be a true default, and you have to divide the assets 50-50. You cannot, on a default judgment, list your assets, say, I have $200,000 in my 401k, and then say, I'm keeping all of that and my spouse is getting nothing. that'll never get approved through the court because community property listed on the property declarations when you do the defaults need to be divided equally, and that's just a matter of law. Now, with our clients that are going through an amicable divorce, as long as they're both participating, the asset and debt division does not need to be divided equally at all. In fact, when we're doing the property order and the marital settlement agreement for the divorce, many times, or I should say all the time, except for a few instances, we're not even listing the values of the assets. So even if the court wanted to get involved in seeing who is getting what and how much, with the way we do the settlement agreements, they don't list the value. So they have no idea who is getting how much. And by agreement, it doesn't matter. The only time we're listing any amount of values is if there's a specific amount going to one spouse, like an equalization payment, say of $20,000, $50,000 will indicate the amount because it makes sense to. If there's a buyout, if there's anything other than an equal division of proceeds from, say, the sale of the home, we'll list values. But generally speaking, our settlement agreements simply say basically a bullet point list of the list of assets each are keeping, and then of debts, and then any other orders. So default with agreement, you guys get to make all the decisions. The court will not interfere. Default without an agreement, the court will insist on everything being divided equally, and it becomes very technically challenging to get those through the court because the other party's not participating. Even more so when there's kids, significant amount of assets, and if you're trying to get alimony or child support or not have any at all, it's just not up to you anymore. It's going to be up to the court. So just to check our comments and see if we've had anyone come through, any additional questions while we've been chatting here the last 20 minutes. So I don't see anything that else has come through, and that was basically the questions that we had come in during the week. If you are going through a divorce in California and you are stuck and you have problems, we do offer a full service solution. We can take over at any point and handle your divorce case. It doesn't matter where you live, as long as you guys are amicable, we can take over. If you've filed your initial petition and then got stuck, we can help you. We've even had people do their entire judgment and have it rejected multiple times before they call us. So it just depends on how much pain you want to go through before you have us give you a hand. So we do offer full service. We do have flat fees. We do work as a neutral third party for both of you. And our service is very fast. Once you submit us your paperwork, let's say it was rejected, we do a full review, correct everything, get it back out for signatures. And then once you have that prepped, we will get it back to us and we will submit it to court on your behalf. So there's no more going to court. People ask us all the time. I guess one more thing I could add to that is our clients do not go to court because we're submitting a full agreement on all issues to the court. There is no hearings. The judge does not want to talk to you because you guys have a settlement agreement that's been signed and notarized, and the court knows that. And so you kind of bypass that entire process. So check in with us next week. I think what I'm going to do is do a live broadcast of completing the judgment in its entirety from start to finish, including every form you would ever need in one long process. I do this every day because we're drafting judgments every day, but I'm talking about the forms specifically. But I think I'm going to go, and that'll probably take me 45 minutes to go through each form and show you and explain to you how we do that from start to finish. So if you're seeing this after the fact and you want to join us, you can see me do that live, and you can ask any questions that might be specific to your needs with your divorce. Tim Blankenship, divorce661.com. I hope you guys are all having a great day and enjoyed this podcast. And I'll put on a little video here that talks a little bit about our service to get a better understanding of how it works.
Going through a divorce is confusing and time-consuming enough as it is. Choosing someone to handle the paperwork and process shouldn't add to it. But all too often, that's exactly what happens. The process is difficult to navigate. There are mountains of forms filled with legal jargon, and the courts won't help you. And think of the time you'll waste and the work you'll miss by going to court repeatedly. Since 2012, Divorce 661 has saved thousands of happy clients from the unnecessary stress and aggravation the process of completing a divorce can cause. Unlike trying to do it yourself, which quickly gets overwhelming, or hiring an attorney, which quickly gets expensive and then seemingly takes forever to complete, Divorce 661 is affordable, fast, and hassle-free. Serving all of California, Divorce 661 specializes only in amicable divorces. Our full-service legal document preparation solution is completed within days, not months, and allows you to work directly with us while we work with the courts on your behalf to finalize your divorce quickly. That means you never have to go to court, miss work, or navigate the complicated and confusing court system on your own. Save time, save money, avoid court. Let Divorce 661 handle the entire process from start to finish. Schedule a no-obligation 15-minute consultation with Divorce 661 today at divorce661.com.